Good afternoon, folks. Welcome to Division 2 of the Court of Appeals. We have one case set on our 1:30 docket and one case set on the 2 o'clock docket. The case on our 1:30 docket is 15CA79, People v. Connor. The case set on our 2 o'clock docket is 17CA1912, People in the Interest of NB. Are the attorneys ready on the Connor case? You should have been provided a handout of our procedures. While we will most likely refer to attorneys as counsel, we may at times use names of counsel or parties. If we mispronounce any name or refer to anyone by a gender pronoun different than their preferred pronoun, we do apologize. Simply correct us and we'll do our best to get it right from then on out. Please remember that the arguments are being live streamed on the internet and will be archived. So if there is sensitive information, you may wish to take care in how you discuss such matters. On that note, if anyone in the courtroom has a cell phone, please make sure it is turned all the way off so it doesn't interrupt us during oral arguments. Argument is for 15 minutes per side. Counsel, you will be responsible for managing your own time, including reserving time for rebuttal. Let's begin.
Good afternoon. My name is Hollis Whitson, and I represent Justin Connor. No one has ever disputed in this case that Justin Connor's pretrial attorney had a conflict of interest and was serving two masters, his own self-interest and Justin's. The issue has always been adverse effect. From sometime in June 1999, when counsel learned that the prosecutor was criminally investigating him for misconduct on that very case, from that moment, all through the rest of the time that he was on the case, for 7 or 8 months, he had a conflict of interest, until he disclosed the conflict and got off the case abruptly in January of 2000. There is a conflict. The only question is whether it's more likely than not that it had an adverse effect on pretrial counsel's representation of Justin Connor. While the briefing contains many adverse effects and lots of analysis, my time with you today is limited. My focus will be on the influence the conflict had on pretrial counsel's representation of Justin Connor during the plea negotiation stage of the case. Now, the people never disputed that there was a 52-year plea offer on the table, and that was proven in court. And they never disproved or disputed the fact that it was active in June, and perhaps in July, but certainly not in June of 1999 when the conflict emerged. But then, the prosecutor's criminal and ethical investigation dropped a bombshell. The attorney was furious, paralyzed, more than he'd ever been in his life. He could not and did not talk to the DA for the entire remainder of his tenure on the case. All communications ceased. He adopted a lay-low, wishful thinking. Yes, ma'am.
So I've spent some time looking at the post-conviction hearing after Connor 3, and at that hearing, the defendant testified, the trial attorney testified, or pretrial counsel testified, the DA testified. I didn't find any testimony where discussions about plea negotiations were elicited. Can you point us to anything where that record was developed?
Not in the Connor 3 remand proceeding. That would be completely outside of the Connor 3 box.
Well, you were remanded to prove adverse effect, weren't you? I mean, that case was remanded to prove adverse effect.
Yes, Your Honor. Yes, Your Honor. But the definition of adverse effect is what limited the hearing below, and what the remand court used to limit the hearing below. The Connor 3 direction was to, and I quote, point to specific instances in the record to identify something that counsel chose to do or not do and who it benefited more. That was the direction. Without the benefit of West, broader strategies and tactics, which is what West brings to the discussion, broader strategies and tactics were not germane to the hearing. the plea bargaining neither benefits the state nor benefits the defendant more. It's not something that occurs in court. That's why the remand court said, well, there wasn't any plea bargaining occurring, therefore it wasn't a critical stage because there wasn't a plea bargain on the record. That's how everybody below was interpreting it, as the Connor 3 limited what could be presented at that hearing. And that's why Justin understands that this court may be remanding, as it did in Villanueva, for a hearing, a West hearing. But the parties certainly didn't have the benefit of West. When the case came up to Connor 3, there had been no evidence about really adverse effects because under the prior case law, under Castro, once a conflict was proven, the defendant won. So there was no adverse effect required under Castro. West overruled Castro. And there was also the Kinney case, which was the other piece of the backbone of the Connor 3's ruling. Kinney set too hard of a standard for adverse effect. And that's where the Connor 3 court got this idea that it had to be specific things on the record, in court, specific decisions, and that we were supposed to have this hearing where the attorneys were testifying about their ethical lapses and what influence they thought it had on their own behavior. But that wasn't at all the hearing that a West hearing will be or would be.
Was it precluded from being a West hearing?
Well, the attorneys did try to get into some tactics and strategies, not in the area of plea bargaining, but the attorneys attempted to get into the area of strategies and tactics related to investigation, and the court very quickly and emphatically shut that down. The court said many times that the hearing would be limited. In a pretrial order, the court said the factual and legal issues will be strictly limited to those in Connor 3. At the hearing, the court said over and over, that's all I'm going to entertain at this hearing, the specific findings from Connor 3. And in its final order, it said it had been limited. It sustained objections, and it shut down inquiries into at least the investigation tactics and strategies. So applying West, which is really the only standard that's still standing after West, having overruled Castro and said that Kinney was inappropriate for use in conflict cases, the only standard there is West. And no, neither the district court nor the parties have had the benefit of West at this hearing. West is an easy question in this case. The first two parts of West are very, very simple. They ask simply whether there was a plausible, reasonable alternative strategy that wasn't pursued. Clearly, plea bargaining is a plausible, reasonable alternative, happens in almost every case, especially when the co-defendant is going to be testifying against you at trial, and especially when a key witness is going to testify that you asked him to lie on the stand. So plea bargaining clearly meets the first two West criteria. It's this adverse effect that's the question. And no, there wasn't a full hearing on adverse effect, not under the West standards. But the West third prong is easy to see as well, because there was an adverse effect, because there's a link. What the West asked is the link between the conflict and the attorney's failure to take the alternative strategy. The plea negotiation strategy was inherently in conflict with the attorney's loyalty to his own self-interest, his livelihood, his ability to protect his reputation, his income, practice law. His loyalty was to his career, his law firm, himself, his reputation. This is a very powerful drive, the motivation for self-preservation. And that's why in West they made clear that what we don't want is attorneys down there arguing and discussing their ethical lapses and so forth. West actually quotes Holloway versus Arkansas, where the court observed that to assess the impact of the conflict on the attorney's options, tactics, and decisions in plea negotiations would be virtually impossible. So they framed a different test. And here, the test is whether or not there was a conflict, an inherent conflict. And there was. It's black letter conflict law that an attorney cannot negotiate a plea bargain with the prosecutor who is also investigating him in the same case for a crime. It's just been known for a very, very long time in every court that's ever looked at it. An attorney cannot negotiate a resolution of his own accusations and those of his client at the same time. This is an inherent conflict. It satisfies West. Also, the attorney's interest in clearing his name and disproving at trial what this witness was saying about him, the attorney, is inherently in conflict with settling the case with this dark cloud unresolved forever. It's another inherent conflict. We also know that this case satisfies the second subpart of West. West gives a completely independent alternative way to show the adverse effect. And that is to show that the plausible alternatives, plea negotiations, was due to the divided loyalties. And we meet that. The attorney testified that his fear that he was going to lose his license and maybe his freedom kept him from even talking to the DA about anything. Also, the attorney's secrecy demonstrates it was influencing him. He kept his client out of in-camera meetings where issues related to bar were discussed, and he and the DA, almost in a silent collusion, never told for all these months the court or the client that the attorney had a legal, disqualifying conflict of interest. In Ragusa and Delgadillo, the attorney's secrecy was a very strong indicator that the conflict was influencing the representation, which is the question on adverse effect. Did this conflict influence that attorney's representation? Of course it did. Now, in these situations, courts shape a remedy for the violation of the right to conflict-free counsel. And there's a lot of cases in the briefing, and we appreciate the court's indulgence with the briefing. But I want to flag just one, the case of United States versus Williams. In that case, the attorney was under criminal investigation for 2 years as a pretrial attorney. When he was finally indicted, he got off the case, and a new attorney came in and did the trial. But the Second Circuit found a way to grant relief to the client anyway, because for that 2 years, the attorney never pursued plea negotiations. And that was enough to establish a conflict, just like here, and a remedy was crafted. Now here, we even had an offer on the table, an even stronger case. So while Justin believes that this court has enough information to find an adverse effect from this undisputed conflict of interest, both in the plea negotiation example and the examples in the brief, Justin also understands that this court may need to remand this case.
Ms.
under
Whitson,
West
how
versus
could we
People.
find an adverse effect when there is no testimony that Mr. Connor would even accept a plea agreement?
Well, that is a couple of things on that, Your Honor. First of all, that is an outcome-oriented question. That is a Strickland question. That is not a West question. That's not in, and it's one we intuitively go to, but it's a Strickland question. And that's not what's here. It's a different analysis. It's not dispositive or even relevant. With conflicts, there's not an outcome determinative-oriented analysis. West says it's too hard to determine those. But in any case, Connor was being represented by an attorney with a conflict throughout that time. So even if there had been testimony about, with conflicted counsel, what would Connor have done? I mean, that's an outcome-oriented test prohibited by West, but also it wouldn't be a very reliable answer. That's exact.
Well, West does prohibit it, but it overruled Castro, which you're almost arguing for per se prejudice. I mean, there's got to be something on adverse effect. It's not just per se anymore.
Adverse effect is the effect on concilia's representation. And we're not shirking that duty. And if this court believes that a remand is necessary so that the court can use West and the attorneys can know, I mean, in Connor 3, these outcome-oriented questions about what would happen later and, you know, questions that I believe Your Honor's question fits into, the burden was actually put on the state in Connor 3. In Connor 3, the court said if there's a conflict, the presumptive relief, this is page 25 of their order, the presumptive relief is going to be a new trial unless the prosecution proves that the trial was unfair. So put in the plea bargaining context, at the Connor 3 hearing, that burden would have been on the state. So if the burden's on Connor to present that kind of evidence, we implore this court to remand so he can meet that burden, but that was not the burden set forth in Connor 3. The burden was on the people.
Is it your position that he would be entitled to a new trial if there was an adverse effect from counsel's conflict?
I think when this court looks to fashion a remand, there are some examples. U.S. v. William points the way. Our position is that a new trial is the presumptive remedy still today. But at the same time, we think the court can fashion a remedy to put him back.
Yeah, why wouldn't it be, make the plea offer and he either can take it or not? And that's the only remedy. Why wouldn't that one be an appropriate remedy?
If this court disagrees with Mr. Connor on his trial-related issues, then I think that would be an appropriate remedy. I think it would be appropriate, and it would be reasonable for the court to say, why should we give him a new trial if the only issue is the conflict on plea negotiations? If you reject all the other adverse effects, then yes, that's exactly what the court would do. But whatever happens, even if it's after a remand, the Colorado courts, having recognized that this is a conflict, needs to fashion some kind of a remedy. I'll reserve my last 45 seconds for rebuttal, unless there's further questions.
Thank you, counsel.
Good afternoon. May it please the court. My name is Kathy Gillespie, and I represent the people of the state of Colorado here today. My registration number is 26109. I want to start with a couple of points of contention with what defense counsel just talked about, and then I want to back up a step and talk about what we raised in our answer brief, which is that it's a Strickland analysis and not a West analysis. But I want to start by saying there absolutely is a dispute that there were any plea negotiations going on in June of 1999. This court is correct that in the 2013 remand hearing after Connor 3, there was absolutely no discussion about plea negotiations at all, despite the fact that pretrial counsel and an expert, Garash, who was also trial counsel, testified at that hearing, as did the defendant. We also take issue with the fact that defense counsel is stating that Connor 3 didn't ask for a West-type hearing, and so plea negotiations would not have been something that would have been raised at that remand hearing. Starting on page 16 of that Connor 3 opinion, this case was remanded to determine whether or not pretrial counsel faced a situation inherently conducive to and productive of divided loyalties, determine the duration of the conflict and whether it adversely affected counsel's performance as required under Kinney, identify all the critical stages during the time of the actual conflict, and whether there existed more than a minimal risk that the absence of defendant's counsel would deny him a right to a fair trial, and determine for each critical stage whether defense counsel was facing multiple alternatives and whether or not he chose specific alternatives based on that conflict of interest. Now, I agree that the Connor 3 court didn't have the benefit of this Supreme Court's case in West, but it did have the U.S. Supreme Court case law in Sullivan and Holloway and Mickens when it issued this opinion. The evidence that was presented throughout that hearing established that there was no evidence at all that a plea negotiation was still on the table. The only time there was ever any evidence of the plea negotiations was in the remand hearing in 2009, when the issue was an ineffective assistance of counsel claim and whether or not the pretrial counsel had been involved in the falsifying the alibi. Whether you are under Strickland or West, the burden is never on the people to present evidence to meet the defendant's claims. Here, in 2009, pretrial counsel testified that from the very beginning of trial, from the very beginning of the case, they were going to trial. He did say that there was an offer originally on the table of a second-degree murder with a stip to 52 years. But he also testified that 2 or 3 months before the trial date, which would have been the August 1990 trial date, he met with the defendant and his family and went over the pros and cons of going to trial and discussed with them whether or not negotiating a plea bargain was something that they wanted to do. There was no evidence presented by the defense as to the parents or the defendant's answer to that question, We can assume, since Barr did not give his, or the defense attorney didn't learn of Barr's accusations until July of 1999, that plea offer was never accepted. They were set for trial. They were going to trial. They had gone through motions hearings. They had gone through pretrial and status conferences. So there's simply no evidence that was presented which would meet Strickland or West that there was any plea negotiating going on after that first offer was made. And there was nothing that indicated in the 2013 remand hearing, when they were given the opportunity to address this conflict of interest in critical stages, that that was a critical stage that they were arguing about. In fact, their entire hearing addressed the motion to continue the trial and the waiver of the speedy trial that the defendant gave in order to get to that January date. I would like to back up and just address the court quickly on Strickland versus West. And I go through the different cases and the language out of the West case that the Colorado Supreme Court stated and that this court stated in Thomas and Villanova as well. But the question is whether or not this type of conflict has a high probability of prejudice that would equal the situation where a defendant is completely denied his right to trial by a joint representation with his attorney, or that the likelihood of the verdict is so unreliable, or the likelihood of an unreliable verdict is so high. And the people's position in their brief and today is that this type of situation where we have no objection from defense counsel below, this wasn't even raised until we were on our third trip up to a division of this court. It was only an allegation through pretrial counsel. After the allegation came to light and that the prosecution was actually going to attempt to call Barr and introduce the false alibi, pretrial counsel got off. Mr. Garash got on. He had 8 months. He testified at the remand hearing that he completely looked at the case with fresh eyes. He was permitted to litigate multiple pretrial motions, including the motion as to whether or not the prosecution could introduce evidence of Barr's testimony that the defense and the defendant's family had helped him fabricate this alibi. He went through trial and sentencing, and he testified, Garash also testified at the 2013 remand hearing, that it was his opinion that it was not necessarily an immediate conflict of interest, that there were reasons for pretrial counsel to stay on the case to see whether or not, or to try and prevent the prosecution from calling Barr. So when you look at all of the cases, Sullivan, Holloway, Mickens, and West, all involved cases with joint representation of co-defendants that took place from the start of the case all the way through sentencing. In those type of situations, and in the co-defendant or in the joint representation context, the court has found that prejudice is presumed if the court finds that there is a conflict of interest and that conflict of interest is what caused pretrial counsel or any counsel to make the decisions they made on critical stages of the hearing. Here, we don't have that in this case. There's absolutely no case law to support a finding that West should be applied in this type of a situation of conflict cases. And just to circle back, whether it's Strickland or it's West, it remains the defendant's burden under both to either show deficient performance and prejudice or to go through the factors under West that talk about the conflict was there and the reason why defense counsel took certain positions was as a result of that conflict, and that he ignored objectively reasonable other strategies and tactics. In this case, I think the Connor 3 court made, or the trial court after Connor 3 did an amazing job of going through each of the critical stages, talking about the evidence, and that there was simply no evidence that there was a decision that was made or an objectively reasonable strategy or tactic that was not taken by pretrial counsel as a result of this conflict. So I would encourage the court to keep the eye on the ball as to what the purpose of the 2013 remand hearing was, Defense counsel had every opportunity to address the plea negotiations, and they didn't, despite the fact having witnesses there. In 2009, when they did have the opportunity and did bring it up, they still didn't raise enough facts or evidence to support a finding that there was plea negotiations were not taking place because of pretrial counsel's conflict with this fabricated alibi.
Ms.
And I would also,
Gillespie? Oh, pardon
sorry,
me.
go ahead.
Just hypothetically, if we conclude that we can't resolve this given West, what is your position on the remedy? Is it just reoffering the plea? Is it a new trial? And where are the people on the remedy?
Well, I think if the remedy, which I think the trial court pointed out, is if he had ineffective assistance of counsel, he had a trial with effective counsel. And there's nothing to indicate that he would have taken a plea bargain, that plea bargain was open. And I think the remedy of allowing him to go back and take it now allows the defendant to play both sides of the coin. So I'm not going to bring this evidence up at the remand hearing. I'm going to go to trial, take my chances. But when I lose, I'm going to come back and try to claim a right, constitutional right, to this plea bargain that may have been offered back in the beginning of the case. And again, there was no evidence that offer was still open even before, at the time that Barr went in and was interviewed by the police. This could have been an offer that was made at the start of the case, and once prelim was set, it was taken off the table.
So your position is that if there's a remedy, it would be for a new trial?
No, if my remedy would be, even if there was a conflict that affected some of the decisions at the pretrial stage, a new trial doesn't give him anything different than he's already received, because this counsel didn't represent him at trial.
Well, then what remedy would be if there was a conflict that did affect some of those decisions? Are you saying there is no remedy at this point?
Well, I don't think there's the need for a remedy. I
know, but I'm assuming something. I'm assuming that there was a conflict that may have affected the decisions. What kind of remedy would there be?
I think if this court finds that there was a conflict of interest and finds under West that it adversely affected and that West is applicable, then I think the case law is clear. It's a new trial. I think if it's any other questions? Thank you.
Thank you, Counsel. Counsel?
Thank you. The evidence is that Consilia knew about the conflict in June, not July, and that's well documented in the record in the briefing. And I think the remand court found that he was aware of the conflict in June. The testimony in the hearing of September 3rd, 2009, page 30, is that the parents came into his office and discussed the pros and cons of the plea deal at that time. And Justin was in jail at that time, so Justin didn't go into the office. Second of all, of course, there are numerous cases throughout the brief that show that Kyler versus Sullivan, not Strickland, is the appropriate standard to use.
Thank you, Counsel. Thank you both, counsel, for your excellent arguments. The case will stand submitted, and a written opinion will issue in due course. Call 17CA1912. And I was reminded by one of our division members that counsel for one of the parties has indicated they will not be appearing. Are counsel who are present ready?
Yes, Your Honor.
And I'll restate my opening statement, since I think both of you came in after I made them. You should have been provided a handout of our procedures. While we will most likely refer to attorneys as counsel, we may at times use names of counsel or parties. If we mispronounce any name or refer to someone by a gender pronoun different than their preferred pronoun, we do apologize. Please simply correct us and we will endeavor to get it right from then on out. Remember that arguments are being live streamed on the internet and they will be archived, so if there is sensitive information, you may wish to take care in how you discuss those matters. On that note, if anyone in the courtroom has a cell phone, please make sure it is turned off so it doesn't interrupt us during the oral arguments. Argument is 15 minutes per side. Counsel, you will be responsible for managing your own time, including reserving time for rebuttal. Well, there won't be a rebuttal, will there? Let's begin.
Your Honors, I'm at a bit of a loss here. I didn't request oral argument. I would prefer that the case stand on the briefs. Appellant requested the oral argument, so if there's not going to be an argument by appellant, I would ask the court if it would still like me to present something on my side.
Actually, I have some questions for the department, if you don't mind.
Certainly.
Okay.
I do too.
And I understand if you don't want to give a formal argument, if you just want to respond to questions, that's fine.
Sure, but maybe we should start there. That'd probably be good.
In reviewing the various hearings, I was trying to find where the court made these good cause findings on the placement in foster care. Can you point us to anything specific, because I couldn't find it?
All right. There was one portion, and it may take me a while just to find that, and I think I addressed that in my opening brief. It was toward the beginning of the case. It may have even been at the initial emergency hearing. Let me see. Are you asking about good cause findings in relation to the initial removal, or are you talking about with regard to deviating from ICWA preferences?
Deviating from ICWA preferences for the foster care placement.
All right.
As I understood your brief, it wasn't so much that there were findings as there were circumstances in the record that would have supported those findings.
Yeah, and as I'm looking through here, I don't think that I cited a particular part of the record, but that would be my argument, that there were circumstances that supported those findings.
Well, before we move on, is the trial court obligated to make good cause findings at any particular part of the case or parts of the case? Do they have to revisit good cause findings?
I'm not aware of anything that requires them to revisit good cause findings, such like every review hearing, for instance. I think that when, in fact, ICWA itself doesn't really define good cause. I think that the fact that the circumstances weigh in that favor is sufficient.
Well, the statute seems to say the trial court is supposed to make findings. It's supposed to make findings based on a clear and convincing, evidentiary standard. What's the effect of failing to make those findings? Are they inconsequential?
I don't know that it's inconsequential, but I think that when you go back and look at the record, you can see the support for those findings. You can see that the department clearly looked at all family members. The department clearly looked for tribal placements for foster care that was approved by the tribes. You can go back and see that in the record, and you can see that if there is a lack of explicit good cause findings, then the evidence supporting them is still there.
Well, let me ask you, can you elaborate a little bit more on the department's efforts to identify and determine whether or not placements could have been with family members or extended individuals in the tribe or tribal communities?
Yeah, I can do that. Just a moment.
While you're looking, we've had someone join us. Could you enter an appearance? Actually, you never entered your appearance either, Counsel, so we'll cover both those bases. But first, our new arrival.
Yes, Your Honor, and I apologize. I have down for the notice for today's argument that it was at 2:30, so I apologize for my tardiness previously.
And your appearance,
And I represent the appellant respondent father.
and your name and bar number.
I'm sorry, JR. And my name is Kimberly Engelhardt, bar number 44513.
So to your question about attempted placement within the ICWA preferences, the tribal representative at the trial, at the termination trial, testified that the department had searched numerous family members for potential placements, that those family members either could not pass background checks or were not interested in being involved in taking the children. In fact, the tribal representative described the department's efforts in trying to reach family members as going above and beyond, that they did an extensive search and specifically using the language that the department made active efforts to try to find placement.
And should this have been on the record at an earlier stage of the proceedings? Should this placements and good cause for deviating from placements have been, in a prior phase of the case rather than at the termination hearing?
Well, I think looking back, ideally probably the explicit findings by the trial court at earlier hearings, at placement hearings, perhaps may have been ideal. But again, going back to the idea that although the explicit findings may not have been made, the circumstances and the evidence was all there before the trial court. And it was there before the termination hearing. It was there in reports submitted to the court, periodically reports prior to review hearings.
Are those in the record, Counsel?
Those are in the record, Your Honor. Answering the question more about what placement efforts were made, there was Father GV, his extended family was searched. There were no placement options with his family. Extended family members for the mother were contacted, both the mother's mother, grandmother of the children, and the mother's father, grandfather of the children, were contacted and were not able to take the children into their homes. Extended family for the father, JR, was searched. In fact, JR's parents, an ICPC study was done for placement out of state with his parents. Ultimately, they were approved only for temporary placement of 2 of the children. Permanent placement was not an option with them. So those are some of the efforts that were made. The tribal expert also testified that there were no permanent placement options within the tribe. The department caseworker testified that the department has no available Native American families to act as foster homes. The department contacted the Denver Indian Family Resource Center and was told that there were no Native American foster families available in the state of Colorado. So I think the record is pretty clear that there were efforts to comply with the ICWA placement preferences. But this isn't a case where we're looking at the department deviating from those preferences, or the department having one of those preferences available and doing something else. We're looking at a case where the department went through, tried all of the placement preferences, none of them were available. And so when none of them were available, they did a non-priority placement, I guess you could call it.
Without the trial court making that finding, and if the statute does require it, what remedy? Is it a limited remand to make the appropriate findings? I mean, this happened long before termination, so if the statute does require it, and we're not particularly in a position to make findings of fact, how does that look on remand?
I think it would be a limited remand, and the trial court could look at and be ordered to make a finding as to whether or not there was good cause to deviate.
Based on the record as it was?
Based on the record as it existed.
Was there any dispute as far as the department's efforts and as far as the unavailability of priority placements? Was there any dispute in the record? Did anybody say, no, you didn't check out this or you didn't check out that?
I think the father, J.R., protested that his parents weren't looked at a little harder.
Is that a placement preference under ICWA?
I believe it would be. It's family member. It's not, it's extended family, so it is. I don't believe the Native American heritage was through that father, but they're still family nonetheless. But as I stated, the department did an ICPC study on them. They did a diligent search to determine whether or not they were proper placement. And it turned out that they were approved for temporary placement of 2 children. It was never the study was never conducted on all 3 children, but the department was told by the out-of-state agency conducting the study that if it had been, they wouldn't have approved them for 3. They wouldn't have even approved temporary placement for 3. And the department had concerns because of those individuals' health and age and the high needs of the children. Any other questions?
Can you elaborate for us a little bit about what kind of active efforts were made to prevent, the association with the tribes from falling apart?
Yes, Your Honor, absolutely. I think from the very beginning we see active efforts. We see the department contacting the tribe even before removal, which is something that's not required by ICWA. It's essentially an effort above and beyond what they were required to do. We see active efforts in the adoption of a treatment plan for all the parents. We have the mother who was provided with visitation through the Parent Education Center. She was provided with therapeutic visitation services. She was provided with inpatient substance abuse treatment. And she was discharged from that less than halfway through because of non-compliance. The department got her in another inpatient treatment center, which she ended up leaving early. The department also provided her with outpatient substance abuse treatment, which she declined to participate in, and ultimately she said, I'm not interested in any more substance abuse treatment.
What is the difference between those services and reasonable efforts? Active efforts and reasonable efforts?
Active efforts, I think, by case law, has been established as a higher standard than reasonable efforts. I'm not prepared to split hairs on those and tell exactly what the difference is.
Well, why would these be active efforts rather than just reasonable efforts?
Well, I think the difference comes in when you start talking about what the department did to try to accommodate the culture of the mother. And I can address that. I know that the mother was provided with, as in all these cases, family engagement meetings or family team meetings. At each one of those, the caseworker testified that at each one of those, the cultural priorities or culture was addressed with the mother, and how the department could help address cultural concerns. There was one-on-one conversations between the caseworker and the mother, and the caseworker testified that she specifically had those conversations with her, addressed culture, and did so in an effort to make active efforts. That was her specific testimony. There was communication between the department and foster care providers with regards to cultural, I guess, items that were culturally sensitive, so that the foster parents could address those. There was one instance that didn't turn out as I think everyone wanted to. There was some sage provided for a smudge ceremony. The foster parents were concerned that it wasn't sage and didn't follow through with that. But I think the intent was there that the department be sensitive to the cultural issues.
Counsel, can I go back to the placement issue again?
Sure.
As I understand it, the court ends this proceeding with a directive to keep looking for an ICWA placement, an ICWA priority placement. Is that correct?
Yes, it is, Your Honor.
So how does that play into any of the analysis we've got going or the issues raised on appeal?
Well, I think it demonstrates the fact, Your Honor, that the ICWA placement preferences are always in effect. It's not as though they go away once there's a finding of or placement in foster care outside the preferences. That it's always the department's duty to be looking for those.
Thank you.
Thank you, counsel.
Thank you.
Counsel.
Good afternoon, Your Honors. May it please the court. To begin, I would invite questions from the panel in response to any of the answers that were provided by the appellee. Our position today is that termination could have been avoided in this case, and I am here on behalf of respondent father to argue that, so may it please the court. Termination is the least desirable outcome in any case. Here, there were paternal grandparents who are a willing placement option, and the appellee did note that the ICPC was conducted. The caseworker testified about the ICPC on July 31st, 2017, but I don't believe the ICPC was actually introduced as evidence. According to the caseworker's testimony, the grandparents were approved as foster care placement, not permanent placement. In my experience, that indicates that they were approved as a potential adoptive home, but not as a permanent placement with a relative, which would allow for an allocation of parental responsibilities. So I don't believe that they were approved only as a temporary placement, but rather as an adoptive placement.
Counsel, excuse me.
sorry?
Going back to the placement at the foster care, the original foster care placement, did your client, did Mr. JR, Father JR, argue for his parents as foster care placement then? That early in the case?
I don't believe he did that early in the case.
Okay.
I know that they were provided as an option later and that an ICPC was conducted. So at that point, we have two placement options. Both are potential foster adopt homes. And for whatever reason, the department chose to place the children with non-Indian, non-family members. I recognize that there were some concerns about paternal grandmother's medical issues, but paternal grandfather was approved, and there were no concerns with him. Paternal grandmother may have had some medical issues, but there's no indication that she failed a background check or otherwise presented any safety concerns that would harm the children. In addition to this, the ICPC findings, there's no indication to show that they complied with ICWA in their investigation. Did they weigh the medical issues of grandmother against the need for the children to remain culturally with their family? And all children deserve to remain with their family, but obviously in ICWA cases, we have a heightened standard. Now, if the children had been placed with the paternal grandparents, there could have been additional investigation conducted to see what was the relationship with the paternal grandparents and the parents. Was an allocation of parental responsibilities possible? These things should be explored in every case, just based on a reasonable effort standard, but here we have an active effort standard, and we believe that that was not met. The Congress has recognized a special relationship between the United States government and Indian tribes and their family members. And we have also determined that there is no resource that is more vital to the continued existence and integrity of Indian tribes than their children, and the United States has a direct interest as trustee in protecting Indian children who are members or are eligible for membership in an Indian tribe.
Let me ask you about that. Was father a member of an Indian tribe? The ICWA issue was not brought through father, was it?
No.
Or
Well,
paternal grandparents?
He did raise the issue of a less drastic alternative and the placement option. The ICWA standards apply for the children's benefit, so it's my position that even if the father is not an Indian tribe member or eligible for membership, that these children deserve the protections under ICWA that apply.
Right, so he has standing to set aside the termination order based not on the criteria with respect to him personally, but with respect to ICWA compliance?
As an advocate for his children.
Is there case law on that, counsel?
I believe that the opening brief that I submitted does indicate that there is a preference for the child's family members, and it's a heightened standard for the Indian children. It doesn't differentiate between whether it's the child's side of the family that is of Indian heritage or if it's the child's side of the family that is not. Preservation of the family is key. And because of the historical concerns and the significant number of children who have been removed from Indian homes and put into non-Indian foster care, we have this concern of the breakup of the family. It's always a concern. It's always, the least desirable option in any of these cases.
Wouldn't he have to also be arguing then that mother's rights should not be terminated also?
Well, mother argued that, I believe, as well on appeal.
Well, I'm asking about father. Can father argue mother's, and did father argue mother's rights should not be terminated?
We did not. It's my position that termination could have been avoided and essentially had active or even reasonable efforts been made to vet this possible placement option, that we could have avoided both parents' parental rights from being terminated.
Counsel, if I recall correctly, the ICPC that was done with respect to your client's parents approved placement only for 2 of the 3 children, correct?
Yes.
And that the testimony was that if the 3rd child was added, that even temporary placement would not have been appropriate.
I believe that's correct.
So isn't there a danger that your argument to maintain the family actually would have broken up the family as it related to a sibling unit?
It would have. That could have potentially broken up a sibling group, and that's something that needs to be weighed as far as whether or not we need to preserve Indian families, and weighing that concern, which is obviously significant, against the concern of preserving the sibling bond and the sibling groups, which is also very significant. I don't believe that analysis was made on the trial court level, and the ICPC was actually never conducted. It was essentially, if it had been conducted, here's what we would have said. And again, the ICPC was not introduced as evidence, and there's no evidence on the record to show that they were culturally sensitive to the children's needs or educated as far as, the considerations that need to be weighed in placing these children based
Is-
on federal
Is there any
code.
evidence in the record that potential lack of cultural sensitivity was objected to, made an issue by anyone at the hearing?
I don't believe so. I don't believe so, but the objection was made that the children should have been placed with the parents. And because of the requirements that are implicated in ICWA, they are always there. So the question then becomes, why were they not placed there when we did have an approved ICPC for at least 2 of the children on a foster care basis?
But again, I guess to clarify my question, the department or the witness was never given the opportunity, because no objection was made, to provide better evidence of the cultural sensitivity steps they did take, if they took any. Is
I
that
don't
fair to
believe,
say?
I don't believe an objection was made. And so that issue specifically with respect to the ICPC may have not been preserved on the trial court level. I believe it was because of the objection for choosing not to place there. However, it is also the department and the people's duty to maintain and meet their burden to show that termination is appropriate. And so there is not a requirement, to my knowledge, of an objection, that an objection be made in order for the department to present sufficient evidence to meet their burden in the case.
Hypothetically, if the issue that gains traction, so to speak, is the failure of the trial court to make the appropriate findings of good cause, do you agree that the proper remedy would be a limited remand so that those findings, one way or the other, could be made?
Yes, I do agree with that. I do agree with that, with some limited instructions as to how to proceed. And if those findings can't be made, then obviously there would need to be probably a status report submitted to the Court of Appeals, and then await further instructions as far as how to proceed.
Would this be just a regular remand for further findings, or why would it require a limited remand?
Well, depending on the outcome of the appeal, there could be several issues that need to be addressed on remand. Obviously, we've objected to some notice issues, as well as active efforts, as well as less drastic alternatives. So depending on how the opinion comes out. But as far as the finding of good cause, that does seem like a quite limited issue that would only warrant a limited remand.
I'm glad you offered that active efforts comment, because, again, why weren't the efforts of the department active? Why were they just reasonable or not reasonable? Why were they not active, whatever that is?
That's a great question. In my review of the case law, I know that active efforts is more than reasonable efforts. And the statute, the Children's Code, does define some aspects of reasonable efforts. We also know that reasonable efforts are mandated by the facts specific to each case. So active efforts is certainly something more, and it should also be dictated by the facts of each case.
What, if any, impact does it have that the tribal representative actually testified that active efforts were made and praised the department for that?
Well, that's one party to the case, and the parents still have input. So the court would have to weigh, the testimony and the evidence as a whole, and that is one witness. But I'm not sure that they had the adequate knowledge to know what active efforts would be if they were not the actual caseworker or the parent who were working this treatment plan and looking at placement options and talking about these paternal grandparents who were actually approved. I'm not sure if they were aware of that fact. So We did have several issues that we raised on appeal. I did want to focus mainly on less drastic alternatives and active efforts. Every child deserves active efforts, but under the law, the reasonable effort standard applies to all cases, and then ICWA obviously requires active efforts. We don't believe those active efforts were made, and had they been made, we believe that there could have been a less drastic alternative to termination. So based on those factors, we are asking that the decision be reversed and remanded to the trial court.
So what could have been done that wasn't? Other than your disagreement that the placement would have been appropriate with your client's parents, what efforts weren't made that could have been?
Well, changing the placement was really a crucial thing that failed to happen. And had the placement changed, they could have conducted further investigation. ICPC is a fairly limited investigation. It involves a home study, but they are not observing the children in the home with these caregivers over a long period of time. They're not observing the caregivers and their interaction with the mother, who is a tribal member. There could have been an allocation of parental responsibilities, at least explored, and you can craft a parenting plan that will protect the children from constant litigation and all the uncertainties that people are concerned about with these allocations of parental responsibilities. So the fact that it wasn't
How?
even specifically stating in the parenting plan that the parents are unfit, so they no longer stand on equal footing when it comes to modification, requiring a whole litany of, compliance with the treatment plan before they can even ask the court for a modification. There are ways to craft these parenting plans so that they're not just your normal parenting plan that's subject to litigation down the road. So those protections could absolutely be put in place. The problem here is that those options were not even explored.
Never requested.
As far as placement with the,
Parenting plans, the higher staked parenting plans, so to speak.
generally, if a child is in foster care, parenting plans are not considered an option. If a child is placed with family, then a parenting plan becomes a much more realistic possibility. And there is no guarantee that if it's a termination to adoption, there is no guarantee that the parent's going to have contact with the child post-termination. But it is a little bit more likely under those circumstances. So at least you're promoting more family ties. The child's still with a grandparent that way. But if there is no placement with a relative, it's a pretty futile request to ask for a parenting plan to be issued. It almost never happens. I've never seen it. So,
Thank you, counsel.
thank you.
Thank you, folks, for your excellent arguments and answers to the questions. The case will stand submitted, and a written opinion will be issued in due course. And we will stand in recess. The bailiff may so announce.